We still got a couple on our way, so.
Yeah.
I just want to say, I was not trying to do a gotcha moment on the "So Help Me God" thing. I knew that you I know it was inadvertent, and it probably wasn't on your text. But
It wasn't.
What are you going to go to first?
Oh, we did the subpoena first. I think we'll end with sweetness and light.
Yeah, good luck on that.
The Judiciary Committee will please come to order, a quorum being present. Without objection, the chair is authorized to declare a recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the ayes and nays are ordered. Pursuant to notice, I now call up the chair's resolution authorizing the issuance of a subpoena to Acting Attorney General Matthew G. Whitaker to secure his appearance and testimony at the hearing of the committee regarding oversight of the U.S. Department of Justice. I move that the committee adopt the resolution. The clerk will report the resolution.
Resolution offered by Chairman Gerald Nadler authorizing issuance of subpoena to Acting Attorney General Matthew G. Whitaker. Resolved that upon the adoption.
Without objection, the resolution is considered as read and open for amendment at any time. I will begin by recognizing myself for an opening statement. This resolution is important, although I hope not to have to use the subpoena authorized by it. It authorizes the issuance of a subpoena to Acting Attorney General Matthew Whitaker to compel both his appearance and his cooperation at tomorrow's Department of Justice oversight hearing. The resolution does not cause the subpoena to be issued. I hope and expect that the subpoena will not be necessary, but unfortunately a series of troubling events over the past few months suggest that we should be prepared. On November 30th of last year, shortly after his appointment as Acting Attorney General, Mr. Whitaker, on a phone call with Oversight Committee Chairman Elijah Cummings and me, committed to appearing before this committee for a January oversight hearing on the Department of Justice. In the weeks that followed, however, Department personnel tried to convince us that no such promise had been made, that the hearing was unnecessary, and that at the very least, we should excuse the department from an oversight hearing until some undefined period after the Senate confirmed Mr. Whitaker's replacement. These delay tactics should be unacceptable to Democrats and Republicans alike. They are certainly unacceptable to me. We told Mr. Whitaker as much over the course of the next few weeks as we worked to secure a commitment for his appearance this Friday, that is to say tomorrow, February 8th. Not quite the January hearing he originally promised, but a reasonable accommodation. Nevertheless, as late as last week, we received reports that some in the department were counseling Mr. Whitaker that he does not need to show up on Friday. Again, that's tomorrow. Again, such a development should be unacceptable to Democrats and Republicans alike. There is an additional concern. For the first 2 years of the Trump administration, witnesses have often been allowed a free pass on tough questions in front of congressional committees. For example, when former Attorney General Sessions testified before this committee in 2017, he repeatedly refused to answer questions on the basis that he was, quote, not able to comment on the conversations or communications the Department of Justice top people have with top people at the White House, close quote, because the president might want to invoke executive privilege as to the content of those conversations at some point in the future. This excuse, of course, is ridiculous. The president can choose to invoke executive privilege and instruct a government witness not to answer a specific question. The witness cannot speculate that the president might want to assert executive privilege and refuse to answer a question on that basis. The witness can also invoke one of the very few other privileges recognized by Congress, including the Fifth Amendment right against self-incrimination. Otherwise, the committee can and should expect a direct answer to any question. To that end, on January 22nd, a few weeks ago, I provided Mr. Whitaker with a list of questions we may ask him involving communications he may have had with the White House on various topics. I gave him these questions well in advance, because he deserves adequate time to consult with the White House counsel about executive privilege. In that letter, I asked Mr. Whitaker to notify the committee if the President chose to assert executive privilege with respect to a specific question or questions, and of any privilege issues that he might choose to raise no later than 48 hours prior to the hearing. That deadline has come and gone, and we have not heard from the Acting Attorney General. Therefore, I expect the Acting Attorney General to answer all of these questions without equivocation and to the best of his ability and without asserting executive or other privilege. In order to help the Acting Attorney General to meet these expectations, I am asking the committee to pass this resolution, which will authorize me to issue a subpoena to compel Mr. Whitaker's testimony tomorrow if he fails to meet this obligation. To be clear, this resolution merely authorizes the subpoena if Mr. Whitaker appears in the hearing room as scheduled, and if he provides direct answers to our questions, then I have no intention of ever actually issuing the subpoena. If he does not show up, although I do expect he will, but if he refuses to answer questions that he ought to answer, then we will have the tools we need to ensure that we may adequately meet our own responsibilities. My staff and I cannot have been more transparent about our goals here. We explained the possibility of this subpoena to Mr. Whitaker months ago. We provided him with the questions in advance weeks ago. We consulted with Ranking Member Collins and provided him with a copy of this subpoena days ago, long before the 2 business day deadline contemplated by our committee rules, so that we could schedule this markup if necessary. In fact, we are only voting on this resolution because the ranking member asked us for an up or down vote on the matter, a courtesy we were not afforded in the last Congress when Democrats were in the minority. Congress has a constitutional responsibility to conduct oversight of the executive branch, and a key part of that work is to hold government witnesses to a basic standard of conduct applicable to Democrats and Republicans alike. When we invite officials to testify before this committee, they have to appear. When we ask them questions, they have to provide us with answers or provide us with a valid and clearly articulated reason to withhold certain information. Without the threat of a subpoena, I believe it may be difficult to hold Mr. Whitaker to this standard. Accordingly, and in the spirit of caution, I urge my colleagues to support this resolution authorizing but not the issuance of a subpoena, but not actually issuing the subpoena. It is now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. And I thank you agreeing to hold a vote on this subpoena, and it is appreciated. And I think that it is shown that we can work together. And I think because this is important and it's in keeping with our agreement from the committee's organizational meeting. I think the reason we're asking for this vote is very specific. It's an issue of why we're doing it and how we're doing it. It's unfortunate that this first subpoena is to be issued by this committee constitutes a departure from the norms that have governed subpoena usage here in Congress. As I've said before, the subpoena is a powerful and coercive tool and is a tool that should be used as a last resort, especially when the use implicates the balance of power that exists between Congress and the other executive branches of office. You asked the Attorney General to come testify. He agreed. Both parties engaged in back and forth negotiations and scheduling. That is normal. In fact, your first negotiations, as you just stated, happened before you became chairman and before the new Congress was sworn in. Both parties have worked on this. You and the Acting Attorney General agreed upon tomorrow's testimony. That's exactly how the process should work. You should not be giving a subpoena today, as we're looking at it, for hope that it will work as it's supposed to. But we've taken this a step further. As the D.C. Circuit stated in the United States versus American Telephone, each branch should be cognizant of the implicit and constitutional mandate to seek optimal accommodation through realistic evaluation of the needs of the conflicting branches in the particular situation. That is not happening in this case. A subpoena should only follow a breakdown of an accommodation process, and at the last resort against persons seeking to frustrate the legitimate oversight of this committee. There has been no breakdown here. A subpoena should signal that all avenues to acquire the information and testimony have been exhausted. Those avenues have not been exhausted here. A subpoena should not be used to supplement where the committee is merely worried that a witness might not testify or might not answer questions to the extent of the committee's liking. If that was the standard for a subpoena, many on our side, even in the majority, especially when Attorney General Holder sat at that table and offered under record the executive privilege, which he could not claim. Let's be honest about this. You can't anticipate this, and that's exactly what we're doing. When we understand this, there's no indication at this time whatsoever the Attorney General will not show up and answer questions to the best of his knowledge and confined to the law. Similar to every Attorney General, Republican or Democrat, who's come before him, even when they use privilege, which they don't have, Mr. Holder. It further concerns me that it was originally posed as a general oversight hearing and appears to be actually intended for the sole purpose of embarrassing a witness, asking him these questions the committee knows he will not be able to answer. These include questions that prior attorney generals have refused to answer, and this committee, like other committees of Congress, have respected the institutional prerogative and privilege afforded to our nation's chief executive. This subpoena is nothing short of political theater. It's being staged with the acting attorney general as some mythical protector of secrets. Nothing could be further from the truth. I cannot recall a single instance in which this committee authorized a subpoena for an attorney general for the sole purpose of forcing him to invoke a privilege, risk revealing a privilege, or conversations with the president. As we have both said before, a subpoena is a powerful and coercive tool, and both believe it is a tool that should be used as a last resort. We are nowhere near that place today. But, Mr. Chairman, I also have another interesting question, and I was listening to your opening statement. My question is if we're doing this precipitory for Mr. Whitaker on things that he's already agreed to come and we don't know may come, are we going to just do this for every witness? Are we only going to do it for administration witnesses or any other witness? Is this subpoena about timing? Seeing how, by the way, today in the Senate, our brethren and sister across the side are going to probably bring the next Attorney General out of committee. If it's based on reports, as you said, reports that you might hear, where are these reports and what are these reports? Again, I think the interesting issue here is for us, January, I think for both sides. For freshmen and for all alike, I've been involved in a lot. January is a little bit difficult around here on both sides. Trying to get meetings scheduled and other things through a shutdown was difficult. But having this hearing and having this time for a subpoena in which we're anticipating what might happen. If this is what we're headed down, I'm not sure this is the path for a subpoena. I'm glad we have this opportunity to talk about it. This is exactly what we should be talking about. But until it is there, until it is necessary, then we should have. If he doesn't do what he says, as he has stated, then we can have this argument, not in precipitation, because I'm concerned about the chilling effect on other witnesses who will be willing to come testify voluntarily. And when they see this happen, they'll just hold out. So at this point, Mr. Chairman, I would just say this is not for prime time playing. We need to go back and think about what we're doing here in the bigger picture of this Congress and beyond. With that, I yield back.
Mr. Chairman.
Thank you. 1 second. I want to just clarify a point again. We're not voting to issue a subpoena. The subpoena will be issued only if he doesn't show up. As I said before, I expect he will show up. That's not really the issue. The subpoena will really only be issued if he, if he refuses to answer questions on a speculative basis of privilege. We told him, and we may do this for other witnesses too, because we do want witnesses to, we want to carry on the work of the committee properly. We told him a lot of the questions we wanted to ask him. He had plenty of time. We told him in advance. If the president wants to assert privilege, it's the president's to assert, not his. If the president wants to assert privilege, fine, but we want to know that so that we don't have to compel your answer if the president asserted privilege. But you can't, frankly, waste the time of the committee by speculating, as other witnesses have done, as Attorney General Sessions did, that the president might assert privilege. That is not a valid reason to not answer the questions. That's the point for which we would use a subpoena, if necessary. Now, we asked the Attorney General, the Acting Attorney General, to give us an answer to this a few weeks after we sent the letter to tell us whether they were going to assert privilege. He's not done this, so that's where we're at, and that's why we're doing this. That's why we're authorizing this in case he refuses to answer legitimate questions without, in our judgment, a valid reason for doing it.
Mr. Chairman,
Yes, sir.
and going back to that argument, though, this is the very issue that Attorney General Holder, we keep mentioning Sessions, so let's just go back and get the others, as we're doing this, have issued this, but also you've issued it to the wrong place. This privilege does not exist with the Attorney General. This privilege exists at the White House.
That's exactly right.
But it's not the Attorney General's job to go do the White House. If you wanted to talk about the White House, go to the White House.
No. It is.
Mr. Chairman.
Let me just say this. The privilege does exist at the White House.
Mr. Chairman.
Only at the White House. And therefore, the Attorney General or any witness cannot invoke it. Only the President can assert it. And we've told them in advance, if the President wants to assert it, make that judgment so that the work of the committee can go forward.
Mr. Chairman.
Who seeks recognition?
Mr. Chairman.
Mr. Jordan.
I don't understand this. You expect him to come. He's agreed to come, and yet we're going to issue a subpoena.
No, we're not going to issue a subpoena.
He's told you he's coming. He's told you he's coming a long time ago. You've said now 3 times you expect him to be here, and yet we're going through this. I fail to get what we're doing.
I'll answer your
Mr.
question.
Chairman.
I'll answer your question.
But you expect him to come. He's agreed to come. He hasn't changed that in any way, given you no indication that he's not coming tomorrow.
But
he's been the acting Attorney General for, 75 days, and he's going to be gone in a week, and yet we still have to issue a subpoena.
Okay. To repeat one
I don't
sentence,
get what we're doing.
And then we'll go in regular order.
All right.
The issue is if he refuses to answer legitimate questions. That is why we want the subpoena.
How do you know that until he comes tomorrow and he said he's coming?
Sir, I'm speaking. We don't know that. He hasn't told us what he will do. We asked him. He refuses to say...
Mr. Chairman, that's actually not accurate. He has told you what he's going to do. He said he's going to be sitting at that table tomorrow morning at 10 o'clock.
He hasn't told us about answering questions. Who seeks recognition?
Mr. Chairman.
I seek recognition.
Ms. Jackson-Lee. For what purpose does the gentlelady seek recognition?
I move to strike the last word. I thank the chairman.
Gentlelady is recognized.
I thank the chairman. Let me thank the chairman. Let me thank the ranking member for his opening remarks on the courtesy that the chairman has showed in keeping his word on having a discussion and a presentation, if you will, would not call this a hearing, on the idea of a potential subpoena being issued. And I think the clarity of this is to ensure that my colleagues understand that it is not today that we're issuing the subpoena. But let me just give some groundwork and a foundation for where we are today. From January 20th, 2017 to January 3rd, 2019, meaningful congressional oversight has been non-existent. On one hand, we've had the individual cabinet officers come to Capitol Hill for my colleagues, and they have refused to answer pointed questions legitimately related to this body's constitutional mandated obligation to conduct oversight of its co-equal branches of government, citing claims of executive privilege. That has been done without actually asserting the privilege, therefore thwarting attempts by Congress in ascertaining the truth. This is not the way that the 3 equal branches of government under Article 1, Article 2, and Article 3 work. And therefore, it is important to avoid that in the coming hearing. Voters in November delivered a resounding message. One of them is that we want oversight. By the way, they elected over 100 women who, as I've met many of them, are astute lawyers, professionals who want the truth for the American people. So we're here today for 2 reasons, voting to, in essence, not to talk about issuing a subpoena, but to be able to be ready if it is necessary. We have a constitutional obligation to conduct oversight, and our main issue deals around Russian interference in the 2016 election, why the former FBI Director James Comey was fired, what the Attorney General assessed when he did not recuse himself as it relates to the Mueller investigation. There are a number of issues. The allegations at the heart of this case, whether a hostile foreign party subverted our democracy, it is important that we are assured that this Attorney General comes prepared to answer legitimate questions. The deadline for lodging any objections or otherwise notifying the Congress of basis for invoking executive privilege was yesterday. We have not heard anything. This is a reasonable response, not a vote today to issue a subpoena, but to be able to do so for the American people, not for individual members of Congress, but for the American people. Mr. Whitaker may very well show up, having been called by the White House, and not completely answer our questions or raise the issue of executive privilege on the basis of being told to do so by counsel out of the White House or anyone else. I believe preemptively moving forward is an important step that we should do. Put another way, authorization does not mean issuance. I believe issuance or authorizing the subpoena to Matt Whitaker is entirely appropriate, and I'm supporting the authorization of such, but I also want to say to our colleagues, we're doing exactly what you asked us to do, is to bring this forward in a transparent manner. We are relying on the Constitution, but we're relying on what is a collegiate and a sense of operational courtesy in this committee. Let me just cite, as I submit two documents into the record and ask unanimous consent, a quote from the chairman of the Oversight Committee, Chairman Issa. After Mr. Obama was elected. We would like to have hundreds of hearings. I want 7 hearings a week for 40 weeks. That is the chairman of the Oversight Committee, a Republican. Listen to what happened with Mr. Burton, chairman of the Oversight Committee, during the presidency of Mr. Clinton. Burton issued 1,052 unilateral subpoenas during his 5-year chairmanship, according to a calculation by the committee's minority staff. In 2015, Republicans changed the rules again, expanding unilateral subpoena power to 14 committee chairmen to help them go after Barack Obama's administration. Here we are, open and transparent, preparing to get the facts on behalf of the American people. I want to thank the chairman for his vision in handling this, but more importantly, I want to thank my colleagues on the other side of the aisle for accepting and recognizing how transparent Democrats, newly elected, are. And I know they will appreciate working with us on this matter. Mr. Chairman, with that, I yield back.
Mr. Chairman.
Mr. Chairman. The resolution is now open for amendment. Are there any amendments?
Mr. Chairman.
Who seeks? The gentleman from Ohio.
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, I've been on this committee a long time. In most of those years sitting on that side of the aisle rather than this side of the aisle, but that's the way things sometimes go. And I'm not aware of any precedent on this committee where we have issued a subpoena. I know you're indicating, well, we're not actually issuing until he doesn't speak, but in essence, it's issuing a subpoena when a person has already agreed to testify here. And for everything we know, he's going to be
the gentleman yield for a list of such subpoenas?
I'll be happy to yield.
Thank you. The committee issued a series of subpoenas for voluntary witnesses last Congress under Republican leadership. Under Republican leadership, the committee issued 5 subpoenas for voluntary witnesses. I can list them here.
Okay, well, we'll go through that. Reclaiming my time.
And under Republican leadership, the committee threatened to issue an additional 7 subpoenas for voluntary
Reclaiming
witnesses.
my time. The government is a very powerful thing. They can, we have an agreement with the government, essentially. A lot of our rights, we defer for a whole range of reasons. The government, all levels of government, they can literally require you to hand over your property in the form of taxes. They can tell you whether, not the federal level, but other forms of government, they can tell you what speed you have to operate a motor vehicle, or whether you can, this is a motor vehicle that you've purchased yourself with your own money. They can tell you whether you can operate it, how fast. They can now, under the Affordable Care Act or Obamacare or the Unaffordable Care Act, as a number of us have referred to it over the years, they can tell you what your health care, what doctor, essentially. They can tell you how much you have to pay your employees. There's a whole range of powers that the government has, and they can actually require you to appear at a time that may or may not be convenient to you, at a place that may or may not be convenient to you. The subpoena power is one of the more powerful things that the government has. And again, I think in this particular case, when you have an individual who has indicated, and there's not been any indication that he isn't going to appear, that you're going to subpoena that person, I think it's an abuse of the powers that we have and this committee has. So I would ask that you reconsider this at this time.
The gentleman yield to me.
I'd be happy to yield.
Just a clarification for the majority, also the ones that listed was just given as an example was also for depositions, not for hearings before the committee by the acting attorney general or any other administration witness at that time. Those were for depositions.
I'd be happy to yield. The gentleman from Ohio.
2 weeks ago in this room, the chairman said this: a congressional subpoena is a powerful and coercive tool. It should be used only when our attempts to reach an accommodation with the witness have reached an impasse. Where the heck's the impasse? New definition of impasse is the witness has agreed to come, and that's an impasse? I mean, this is ridiculous. The guy is coming. In less than 24 hours, 23 hours and 25 minutes, he's going to be right there, and we're going to get to ask him every question we want. And as the chairman has said repeatedly, we expect him to come, and yet we're going to.
Will the gentleman yield? I'm happy to try to answer his question.
Not my time. It's the gentleman from Cincinnati's time.
Yeah, I'd be happy to yield. The gentleman from New York, Chairman.
Thank you. If, in fact, the Attorney General, as I said before, the real issue is answering our questions. If he does, the subpoena will not be issued. If he uses a specious thing like maybe the president wants to assert executive privilege when he hasn't checked, although we gave him ample notice to check, then we will have the discretion to use a subpoena. That's the purpose of it, to make sure we get answers to our questions.
Mr. Chairman.
Reclaiming my time. So in essence, I think you essentially have the sword of Damocles hanging over this guy's head. It's unnecessary. It's unreasonable. Another power that I didn't mention that used to occur a lot, we literally could draft people into the military and essentially require them at cost of going to prison to fight and perhaps die for our country. So this is a committee that we always take serious those powers and not overstepping those powers. And I know the chairman, because I've seen him in action before, those things are generally very important to him. I, for 6 years, was the chair, and the gentleman who's now the chair of this full committee was my ranking member for 6 years in the Constitution Subcommittee. So we investigated these issues. We had 13 hearings on the reauthorization of the Voting Rights Act, 46, I believe, witnesses. So we've worked together on those things before, and I hate to see the reputation that my colleague, my gentleman, my friend from New York has damaged unnecessarily by moving ahead. I just think it's unnecessary, and I would ask him to reconsider, and I yield back my time.
Mr. Chairman. Mr. Chairman.
Who seeks recognition?
Mr. Cicilline here at the end, Mr. Chairman.
The gentleman from Rhode Island.
Thank you, Mr. Chairman. I move to strike the last word.
The gentleman is recognized.
I want to thank the chairman for his very prudent action in proposing this resolution and make the initial point to my friends on the other side of the aisle. Our oversight responsibilities are not merely satisfied by a witness physically appearing. It is by a witness physically appearing and answering questions posed by Congress. That's the actual function. And so what the chairman's resolution does is it ensures that we do not have the experience that we have all had on this committee before, where witnesses come as they're asked to do voluntarily, and they take an oath, and then they avoid answering questions. They say the questions make them uncomfortable. They're hard. Maybe the president would invoke a privilege if he were here and directing them. And so to avoid a colossal waste of time, the chairman of this committee did something really extraordinary. He wrote a letter to the witness and said, here are the questions I'm going to ask you. Out of respect to the members of this committee, if you intend to invoke a privilege, take whatever steps you need, have whatever conversations you need to have with the executive branch so that you do not come before the committee and flounder around and claim to invoke a privilege that might, in fact, never be invoked. That's a prudent action by the chairman of this committee to respect the role of Congress to do oversight and to be sure that witnesses understand that central to our ability to do oversight is our ability to collect information. And it's not up to administration witnesses just to decline to do it because it makes them uncomfortable. We had that experience with the Attorney General, Jeff Sessions, and many other witnesses. And so why did the chairman of the committee think it was prudent? Because a witness originally committed to coming, then tried to back out of the obligation, because the witness did not respond to the chairman's letter at all, which makes you wonder, has he in fact had these conversations? And because we've had a parade of administration witnesses doing the exact same thing. So this is a sensible, responsible thing to do. The chairman has done it in a way which is fully transparent. I don't know of another witness who gets the questions ahead of time, but out of the spirit of cooperation and an effort to really show that we're trying to get at these important facts, the chairman has done that. And look, we have oversight responsibility. We were elected to do that. Many of us have sat on this committee in incredible frustration that we were not able to get critical questions answered. And our Republican colleagues, as I have said before, acted more like defense lawyers for Donald Trump than independent members of the legislative branch with oversight responsibility. And so the purpose of this authorization is to be sure that when that witness comes here, the chairman has the ability to compel him to answer questions that he is required to answer by law. We all ought to be interested in that. We all ought to be interested in getting the facts and to doing our oversight. And I just want to applaud not only the long and extraordinary reputation of the chairman, but also really applaud him for thinking about ways to ensure that we can do our jobs consistent with our constitutional responsibilities to do it in a transparent way, to do it in a way which ensures that we get this information. And I really applaud him for this, and I'd like to yield to Mr. Swalwell, who has some additional.
I thank the gentleman, and I thank the chairman for having the foresight to anticipate potential issues. Now, if yesterday had never happened, if the days leading up to this hearing had never happened, I could understand the ranking member and my colleagues' concern that this may not be necessary. But for the last 2 years, we have seen in front of this committee, and I have seen in the Intelligence Committee, just effort after effort to either invent privileges that don't even exist, refuse to testify, obstruct lawful investigations. And I think to save time and cut to the chase and make sure that the witness knows that there's recourse for us to get to the bottom of this, this is the appropriate thing for this committee to do. So I will support this. I support the chairman, and I yield back to the gentleman from Rhode Island.
I thank the gentleman.
Mr. Chairman.
I thank the gentleman for their sentiments. Who seeks recognition? Mr. Biggs.
Thank you, Mr. Chairman. I have an amendment at the desk.
You have an amendment at the desk? Is an amendment at the desk?
I have an amendment arriving at the desk.
Mr. Sicily, what?
It's flying in right now as we speak.
Yeah.
I don't know what it is.
Who is that, Mr. Chairman? I'm just wondering.
You can reserve the point.
So, Mr. Chairman.
Mr. Chairman, I reserve a point of order on this amendment.
Amendment to resolution authorizing issuance of a subpoena to Acting Attorney General Matthew G. Whitaker, offered by Mr. Biggs of Arizona. Beginning on page 1, after Acting Attorney General Matthew G. Whitaker, and before to secure his appearance, insert the following, and Deputy Attorney General Rod Rosenstein.
The author of the amendment is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. I've heard a lot of interesting arguments this morning that I find somewhat bizarre to me. The chairman in his opening statement talked about the use of a subpoena as a threat. My colleague from Rhode Island just was talking about how prudent this was because the questions had been provided previously. Well, I'm just curious to know, if this all the questions Mr. Whitaker is going to be asked? The answer is no, because each of us will get our chance and we'll spend literally hours asking questions. So what the chairman is asking for is not necessarily to be able to provide a subpoena if his questions aren't answered in a manner that's satisfactory to him. He's leaving it wide open, carte blanche, if he's not satisfied with his answers to my questions. That becomes an extremely broad grant of authority to this chairman. And I find myself asking, how are we going to begin doing this for every witness? Because I think my colleague from Rhode Island just mentioned, and my colleague from California both just mentioned how frustrating it's been to have people come in here where you're getting answers that don't satisfy you as to your questions. If that's the case, then this is just a process that doesn't make sense. It's absurd, because
will always be going to issue a subpoena ahead of time, just in case someone doesn't give us the answers we want to get. And that's important to understand, that is what this resolution before you is today. My point is, when I read the questions, you're asking questions specifically dealing with the Mueller investigation. That's what you want to get at. You want to find out what's gone on in the White House with regard to the Mueller investigation. And you're asking the guy who's been there for 2 months. Why not bring in the guy and ask the guy that was over it for 15 months? I've been trying to get that guy in. I'll just tell you, we couldn't get him in under the last chairman. You get him in, I'll cheer you on. You ought to include Mr. Rosenstein in this if you really want the answers to the questions that you have before you here, that are in the letters that you sent to Mr. Whitaker. That makes sense. That's what we ought to be doing. That's why I've introduced my amendment. With that, I'll yield to the gentleman from Ohio, Mr. Jordan.
I thank the gentleman for yielding. I support the gentleman's amendment. Look, this is simple. Rod Rosenstein, it's been in the press. It's alleged that he was contemplating wearing a wire, talked to subordinates at the Justice Department about wearing a wire to record the President of the United States. New York Times also reported Rod Rosenstein was looking at invoking the 25th Amendment. We heard testimony from the chief counsel, former chief counsel at the FBI, Jim Baker. He believes that was actually being contemplated by the Deputy Attorney General. Rod Rosenstein has threatened staffers, according to media reports, threatened House Intelligence Committee staffers. And as we all know, Mr. Rosenstein tried to hide information from us. Redacted from information the Judiciary Committee received in the last Congress was the idea that Peter Strzok, the now famous Peter Strzok, was friends with one of the FISA judges. That was redacted.
Would the gentleman yield?
Sure.
I've just noticed that the gentleman, there he's coming back on. I didn't know if it was personal. But
say it again?
You just disappeared here when you were talking, Jim. I'm not quite sure what happened here.
So, Mr. Chairman, I support the gentleman from Arizona's amendment. I think it is exactly, if we're going to do this, let's add the guy who can answer the questions that we all need answered, more importantly, that the American people want answers to.
Reclaiming my title, I yield to the ranking member.
Thank you, and I also support this amendment. Again, this goes back, again, part of the issue here is we understand what's going on here. The problem is the Deputy Attorney General, who's, as the gentleman from Arizona has said, has come here and repeatedly been frustrated on both sides of the answers, and the answers we've not gotten. So I think what we're looking at here is this is the way it should work. He came, he didn't do what we want, this is the answers we didn't get. And I think both sides could actually agree on that. Y'all got answers y'all didn't get either. And so this is the way it actually, should work in the process. If we're going to use a subpoena, let's use a subpoena as it is. The sad part about this is we're also sort of going back, and I think the chairman has talked about this on many occasions already, that previous witnesses here have not complied and they come forth and they've used issues that actually were hearing used and could have been on a subpoena. And I just have to remind that when the former Attorney General Lynch was here, 74 times would not answer questions. These are the kind of things that are frustrating, but I do support the gentleman's amendment, and with that, I yield back to the gentleman from Arizona.
I'm out of time.
Thank you. Does the gentleman from Rhode Island insist on his point of order?
Yes, I do, Mr. Chairman.
The gentleman will state the point of order.
Thank you, Mr. Chairman. I would argue that this amendment goes beyond the scope of the resolution before us, which deals with a single individual, Matthew Whitaker, responsible for oversight of the Department of Justice and is therefore not germane. As the acting Attorney General, he is the one individual at the Department of Justice who has the responsibility for the actions of the entire department. In addition, Mr. Whitaker is the only individual who currently charged with oversight of Special Counsel Mueller's investigation, and because of the manner in which he was appointed and the issues which have come up with respect to whether he should recuse himself from that matter, he has a unique perspective on many important issues before this committee. So the appointment of Mr. Whitaker, the reason for his appointment, the conversations he had with the administration relative to his supervision of this investigation is critical. With regard to the Deputy Attorney General, I would note in passing that both former Chairman Goodlatte and the ranking member at the time had the opportunity to question Mr. Rosenstein on several occasions last Congress. He appeared before the committee on several occasions. He's been the subject of numerous document requests by the committee in the last Congress, and that has in itself led to a variety of subpoenas and responses. So while I wouldn't rule out that we may have some interest in bringing Mr. Rosenstein before the committee before, his addition to this resolution is not germane. It expands the scope of this for the individual charged with the oversight of the Department of Justice, and therefore I ask that you rule it out of order.
Mr. Chairman.
I'm sorry. I'd like to yield to Mr. Liu from California.
Thank you. Let me first say I appreciate that Republicans on this committee understand that we want witnesses to answer questions, which is why they're including Rod Rosenstein in this amendment. And that leads me to think that if both sides are having problems because we don't like it when witnesses don't answer questions, let's just do an amendment that authorizes the chair to simply issue subpoenas whenever he wants when witnesses don't answer questions. So that would be my proposal. It would solve both sides' problems. Let's just give this authority to the chair instead of doing it on a one-off basis, and that's my request.
Mr. Chairman.
Thank you. Reclaiming my time. I don't know if anyone else. I'd yield to the chairman if he has. No, then I yield back.
Mr. Chairman.
Thank you. Does the gentleman from Arizona, the sponsor of the amendment, wish to be heard on the point of order?
Yes, I do. Thank you, Mr. Chairman.
Gentleman is recognized.
Thank you. What I find, do I get a full 5 minutes?
You get 5 minutes.
Okay, just going to that. Mr. Chairman, thank you. Here is what I see, 2 points I want to make on the issue of germaneness. Number one is, while the initial resolution mentioned Mr. Whitaker by name, what we have heard here today, which gives us the scope of what this resolution is to be, what the chairman has said, what the gentleman from California, the gentleman from Rhode Island have all talked about questions and the answers to those questions. That's where they began to move. That allows, I think, an opening of the door because we're now talking about the scope of the subpoena, not just the named individual. So when we talk about the scope of the subpoena, and we're now talking about what the hearing is going to be about tomorrow, and that's going to be Mr. Whitaker and his answers to questions. I think that broadens this thing way, way, way beyond the idea that it's just going to an individual. So when we start talking about the scope of this, we get back to the questions that the chairman is so, and I think appropriately, provided to Mr. Whitaker. And what those do is they broaden what we're going to be, and I think that gets to the germaneness, and that broadens it, and I'll tell you why. Because under the rules of any parliamentary body, this group determines what's germane. This group determines what's germane. We're going to vote on germaneness in just a second. And that means you have to consider what our chairman has said his point is. Why is he doing this? He wants to have the authority to issue a subpoena in case, what? Not because he's not coming. We know he's coming. It's because he's afraid he's not going to give him the answers to questions that he wants. And if that's it, now you've moved to the scope of the hearing, in my opinion. Well done. And that means that we go right into bringing people that we want to hear, and I think you can broaden it, and that's the point.
Will the gentleman yield? Right here.
Yes, I'll yield.
I'd like to also add in response to the point of order that it is extremely germane. You're basically pointing out you want to get into the integrity of the Department of Justice, the FBI, and Special Counsel Robert Mueller's investigation, and you have a guy who is Deputy Attorney General who, as U.S. Attorney, was overseeing the Russian investigation that really was, from all appearances, criminal in the nature of Russia paying bribes, and they had a man on the inside. Robert Mueller was head of the FBI during that, and all of a sudden, he ends up, Mueller does, investigating a Russia connection with the president and being supervised by the U.S. attorney that was over the Russia investigation that they sat on. So we're going to talk about the integrity of the Department of Justice, FBI, Special Counsel Robert Mueller's investigation. We sure, by golly, ought to get into those very issues. It's as germane as it gets. So let's be fair. It is germane just simply on the words in the letter the chairman offered. I yield back.
Would gentleman yield? The gentleman yield.
Who's asking? Yes, I'll yield.
The chair is prepared to rule on the point of order.
I'm reclaiming my time, and I'm yielding to the gentleman from Ohio.
I would just point out this.
Okay.
You want to issue a subpoena for a guy who's already agreed to come because you want to ask him questions about his 70 days of overseeing the special counsel. We want to bring the guy in who has overseen the special counsel for a year and a half, who we know has said he contemplated, told subordinates he was thinking of wearing a wire to record the commander-in-chief, and was talking about invoking the 25th Amendment. All we're saying is add his name. If you're going to go through with this, add Mr. Rosenstein's name so we can ask him some important questions that the American people need to know. I support the gentleman's amendment.
The chair is prepared to rule.
I'd like to reclaim my time and just finish with one last statement, if I can, Mr. Chairman. Thank you. So the point here, the reason that I've proposed adding Mr. Rosenstein is not because we're trying to suppress Mr. Whitaker from coming and testifying. It is because we want to add Rod Rosenstein to get at the heart of the matter of the questions that the chairman has said is the heart of the hearing tomorrow. Well, then let's subpoena in the guy who could probably answer those questions more thoroughly than anybody else. And with that, Mr. Chairman, I urge that you rule against my friend's motion on germaneness, point of order on germaneness.
The chair is now prepared to rule on the point of order. The amendment deals with a different subject matter and purpose and would broaden the measure beyond the current scope. The resolution we are voting on today is quite explicit in that it authorizes a subpoena with respect to a specific individual, the Acting Attorney General Matthew Whitaker. Adding an additional individual, even one who serves at the Justice Department, would clearly change the purpose of the hearing and take us beyond that scope. Allow me to add that there may well be an opportunity for our committee to pose further questions to Mr. Rosenstein during this Congress, but that can and should be dealt with separately from the resolution we are considering today. Therefore, pursuant to House Rule 16, Clause 7, and related precedents, the chair rules the amendment to be not germane to the measure.
Mr. Chairman. I'll hold off. I'll hold off.
Yeah, wait till we vote.
I'd like to appeal the ruling of the chair.
You're appealing?
Yes.
Mr. Chairman.
Mr. Chairman.
Mr. Chairman. Mr. Chairman.
The appeal, the member has stated an appeal of the ruling of the chair.
I move to table the ruling.
A motion to table the appeal of the ruling of the chair is heard. The question is on the motion to table. Motion to table is not debatable. The question is on the motion to table. All those in favor shall signify by saying, that is in favor of the motion to table, shall signify by saying aye. Aye. Opposed?
No.
In the opinion of the chair, the ayes
call.
have it. The ayes have it, and the motion to table is agreed to.
Roll call.
The gentleman asks for a roll call vote. As your name is called, all those in favor of the motion to table shall signify by saying aye. Opposed? No. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Ms. Bass? Or Mr. Deutsch, my apologies. Mr. Deutsch votes aye. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Aye. Mr. Jeffries votes aye. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Askin? Aye. Mr. Askin votes aye. Ms. Jayapal? Ms. Demings? Mr. Correa? Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. McCarcel-Powell?
Aye.
Ms. McCarcel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins?
No.
Mr. Collins votes no. Mr. Sensenbrenner? Mr. Shabbat? No. Mr. Shabbat votes no. Mr. Gomer? Mr. Gomer votes no. Mr. Jordan? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein?
No.
Mr. Klein votes no. Mr. Armstrong?
Nope.
Mr. Armstrong votes no. Mr. Stubbe? Mr. Jordan? Mr. Jordan votes no.
Are there any members of the committee who haven't voted who wish to vote? The clerk will report.
Mr. Chairman, 21 members voted yes, 13 members voted no.
The majority having voted in favor, the motion to table is agreed to. Are there any other amendments? If not, a reporting quorum being present, the question is on the motion to adopt the resolution. I think a recorded vote is appropriate in this instance. Therefore, the clerk will call the roll on the resolution.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Deutsch? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. McCarcel-Powell?
Aye.
Ms. McCarcel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Chabot? Mr. Chabot votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein?
No.
Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe?
Who wish to vote? If not, the clerk will report.
Mr. Deutsch votes aye.
The clerk will report.
Mr. Chairman, 23 members voted aye, 13 members voted no.
Mr. Chairman,
For what purpose does the gentleman seek recognition?
rise to commend the chairman on the way in which he ruled on the germaneness issue. We know that to rule before giving this side a chance to respond on a germaneness objection would be a sign of partisan railroading. And whoever it is that waited until after all arguments were made, typed up your answer and had it instantaneously at the very moment we finished our argument in front of you so you could read it. It really needs to be commended how quickly, where so fast we couldn't even see it. They typed it, got it to you so you could read your ruling the moment we finished stating our position.
Will the gentleman
I thank the gentleman for his comments. Pursuant to notice, I now call up H.R. 948, the No Oil Producing and Cartels Act of 2019, for purposes of markup, and move the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 948 to amend the Sherman Act to make oil producing and exporting cartels illegal. Be it enacted.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. The Organization of Petroleum Exporting Countries, or OPEC, is an international cartel whose members deliberately collude to limit crude oil production as a means of fixing prices, unfairly driving up the price of crude oil to satisfy the greed of oil producers. Such behavior, if done by private companies, would be illegal per se under U.S. antitrust law. Because of a series of court decisions, however, our nation's antitrust enforcers are unable to protect American consumers and businesses from the direct harm caused by OPEC's blatantly anti-competitive conduct. H.R. 948, the No Oil Producing and Exporting Cartels Act, or NOPEC, addresses these decisions by expressly authorizing the Justice Department to pursue antitrust enforcement actions against OPEC members should it choose to do so, and by ensuring that American courts have jurisdiction to hear such cases. I am pleased to join my colleague, the gentleman from Ohio, Mr. Shabbat, as an original co-sponsor of this legislation, along with the Antitrust Subcommittee Chairman, Mr. Cicilline, and the subcommittee ranking member, Mr. Sensenbrenner. NOPEC would amend the Sherman Antitrust Act to add a new section that explicitly makes it illegal for any foreign state to act collectively with others to limit production, fix prices, or otherwise restrain trade with respect to oil, natural gas, or other petroleum products. This provision could be enforced only by the Justice Department. The bill also creates an exemption under the Foreign Sovereign Immunities Act to allow litigation against foreign countries to the extent that they are engaged in price fixing and other anti-competitive activities in violation of this new section. Finally, this legislation clarifies that the act of state doctrine, which generally disfavors judicial review of certain actions by foreign governments, does not prevent courts from deciding antitrust cases brought against foreign governments under this act. NOPEC strikes an appropriate balance between allowing aggressive enforcement of U.S. antitrust law against OPEC to keep oil prices in check and respecting the separation of powers by deferring to the executive branch to determine whether litigation is appropriate, given any foreign policy or national security concerns there may be. In 2007, I voted for legislation virtually identical to this measure, which passed the House with overwhelming bipartisan support. Although 11 years have passed since then, many of the reasons for supporting that legislation back in 2007 remain valid today. OPEC controls more than 80% of global oil reserves, 40% of the world's oil production, and more than 60% of the petroleum that is traded internationally. When acting collectively, OPEC countries can greatly influence crude oil prices. This effort to increase crude oil prices directly impacts American consumers because the price of crude oil is the largest single determinant of retail gasoline prices. According to one estimate, crude oil prices accounted for 50% of the cost of retail gasoline in 2017 and as much as 70% of the cost of gasoline in 2011. And the retail price of gasoline touches almost every aspect of Americans' daily lives, from the cost of commuting to the price of food and almost every consumer good, to the extent that such prices reflect the cost of transporting those goods. High gas prices, in addition to raising these costs and cutting into Americans' income, can also cause a vicious cycle of negative economic effects. For example, when higher prices cause consumers to cut back on purchases and limit their travel, businesses lose revenue, and they may be forced to lay off employees or to reduce their employees' salaries. This in turn unleashes another loop of negative economic effects, as those employees have less money in their pockets to spend. I support this legislation because it would provide the federal government with one tool to address unfair retail gas prices. Nevertheless, I caution that it would be a mistake to think that enacting this legislation alone will fix the problem. Congress and the Trump administration should explore other factors that also drive up gas prices, including an anti-competitive level of concentration among oil refiners, our society's excessive petroleum consumption, and the heightened risk of war and instability in the Middle East. Passing NOPEC, however, would help keep gas prices in check. I thank the sponsor of this legislation. I urge my colleagues to support this measure, and I yield back the balance of my time. It is now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. And moving to now actually legislation that actually is productive and moves forward. I'm excited to join with you in recognizing this piece of legislation and moving it forward. Because OPEC has manipulated the supply and price of oil, this has created a great uncertainty for many Americans who rely on oil to run their households and businesses. Many would argue that OPEC operates like a cartel, so the Sherman Antitrust Act should apply. But the courts, however, have allowed OPEC to escape liability. The No Oil Producing or Exporting Cartels Act, NOPEC, would actually fix that problem. It is a bill with a long history of bipartisan and bicameral support, and today's markup begins consideration of the bill in the 116th Congress. And I look forward to working with my colleagues on this issue. And I have to commend the sponsor of this bill, Mr. Shabbat, who has been working at this tirelessly for years and making improvements, I think, along the way, taking input, and that's the mark of a legislator on both sides of the aisle, is to taking input and making a bill better, and I'm glad to see that. And with that, I'll yield the rest of my time to my colleague from Ohio.
Thank you very much, Mr. Ranking Member, and I want to thank the Chairman, Mr. Nadler. I very seldom get to say that I agree with everything that you said before, and we've been working on this together. And I also want to indicate I'd like to enter into the record a letter of support for NOPEC from the Securing America's Future Energy. It's an organization comprised of retired military officers and Fortune 500 CEOs. Thank you.
That objection, the letter will be entered into the record.
Thank you. And I want to thank you, Mr. Nadler. I want to thank Mr. Cicilline. I want to thank Mr. Collins, Mr. Sensenbrenner, Ms. Jackson-Lee for their support on this common sense legislation to stop anti-competitive behavior in the oil market abroad. As I mentioned, the Regulatory Reform, Commercial and Antitrust Law Subcommittee hearing last year, I first introduced this legislation back in 2000, so it's literally been almost 2 decades ago, along with our colleague then from Michigan, Mr. Conyers, who fought for this for a long time too. And since then, it's been introduced 7 times. Last year, we were able to report it favorably out of committee, and I hope that this year we can get it to the President's desk, who has indicated at various times support for this, and even in a book that he wrote. And while Congress has been considering this legislation over the better part of the last 2 decades, we've seen gas prices rise and fall largely at the whims and influence of OPEC. The average U.S. household pays over $2,000 a year in gas costs, and back in my district in Cincinnati and Warren County, that's a big chunk of their paycheck. Given that 60% of the world's oil is controlled by OPEC nations, my constituents and the constituents of lots of other folks in this room and the American consumers often have difficulty reliably filling their tanks up every week, cars, trucks, et cetera, because the price is oftentimes too arbitrary. Additionally, as former chair of the House Small Business Committee and now the ranking member of the House Small Business Committee, also recognize the impact that rising gas prices have on small businesses all across our nation. As the price of gas increases, so does the price of shipping goods throughout the United States, putting pressure on an already razor-thin bottom line for business owners and ultimately having a negative impact on our overall economy, although the economy is doing quite well, as we all know right now. International oil cartels regularly attempt to manipulate the price of crude oil by limiting production, thereby driving gas prices arbitrarily high in the United States. Ultimately, this legislation allows us to fight back against such artificial market manipulation by holding foreign countries and entities accountable for violating U.S. antitrust law. This legislation is simple. It authorizes the Attorney General, and only the Attorney General, it's one of the changes that was made, to bring lawsuit against oil cartel nations for anti-competitive behavior in federal court. And further, it ensures that nations will have to defend their actions and anti-competitive behavior by removing their ability to use active state, foreign sovereign compulsion, or political question doctrines as defenses or assert sovereign immunity in such cases. In closing, it's high time that we act to pass NOPEC to put an end to OPEC's anti-competitive behavior. And I would just finally note that whereas we're a committee that naturally battles over everything from guns to abortion to subpoenas, and perhaps in the future at some point even to impeachments, as we've done in the past. This is one item, one instance in which we can work in a truly bipartisan fashion. I thank my colleagues on both sides of the aisle for their support on this. urge them to support this legislation and yield back my time.
All right, thank you, gentlemen. I'd now like to recognize the chair of the Subcommittee on Antitrust, Commercial, and Administrative Law, Mr. Cicilline, for his opening statement.
Thank you, Mr. Chairman. Since 1960, the Organization of the Petroleum Exporting Countries, or OPEC, has colluded to manipulate the supply and price of crude oil with total impunity under our laws. In recent years, OPEC members have entered into an anti-competitive agreement with 11 non-OPEC countries, including Russia, to manipulate oil prices by reducing production. In other words, this means that working people in our country end up paying more for gas for their car or heat for their homes. Cartel behavior like this is considered a hardcore criminal violation of the antitrust laws because it's an explicit agreement to collude in order to fix prices, reduce output, or allocate markets. The Supreme Court has referred to this anti-competitive conduct, which has no pro-competitive justification, as the supreme evil of antitrust. But unlike other cartels, foreign oil cartels are free to engage in anti-competitive conduct to fix the price of oil due to legal doctrines of sovereign immunity and act of state, which place firm limitations of the judicial process when it comes to resolving legal disputes with foreign governments. It's time for this to end. And I'm proud to join Congressman Shabbat and the chairman of the committee and the ranking member in introducing the NOPEC Act. This legislation will give meaningful relief to millions of Americans by authorizing the Justice Department to investigate and prosecute foreign oil cartels. It would do so by clarifying that commercial activity by other countries to limit the production or set the price of oil and other petroleum products is not exempt under the Foreign Sovereign Immunities Act or judicial doctrines. While I strongly support the goals of the NOPEC Act, it's important to keep several caveats in mind as we consider this legislation. First, merely removing barriers to antitrust enforcement against foreign oil cartels by the Justice Department, as this bill would do, does not compel law enforcement in this area or constrain the department's enforcement strategies. Instead, the NOPEC Act authorizes the department to investigate and potentially bring these types of cases, which alone may be enough to discourage collusion by foreign oil cartels. Put another way, this bill gives the executive branch a tool to speak softly and carry a big stick. Second, this legislation is designed to serve as a complement, not a substitute to diplomacy and thoughtful engagement with OPEC members and other countries that collude to withhold oil supply. The NOPEC Act is an invitation for any administration, Republican or Democrat, is not an invitation for any administration, Republican or Democrat, to politicize antitrust enforcement or pick geopolitical winners and losers. With this concern in mind, I look forward to including language in the committee report to make this point clear. And finally, the use of antitrust enforcement in this area, if used at all, should be part of a broader strategy toward energy independence. Antitrust enforcement alone is not a silver bullet to lowering oil prices. It must be a national priority to deploy and expand our capacity for clean energy production. I firmly believe that addressing oil consumption rather than oil production is critical to ensuring America's energy independence. Developing alternatives to oil consumption isn't just about combating climate change, lowering energy prices, or decreasing the market power of oil cartels. It's also about creating economic opportunity. In my home state, Rhode Islanders are already hard at work to deploy innovative, clean, efficient energy solutions to deliver clean energy and address climate change. This investment in our clean future is an engine of opportunity in our communities that should also serve as a model for federal policy. It's also important to acknowledge that there are additional forces at play that necessitate passage of this bill immediately. In November 2016, OPEC announced that 11 of its members would cut supplies by nearly 5% for each member, resulting in a $10 increase in oil prices per barrel for Brent crude oil. A year later, OPEC agreed to extend these cuts along with an additional 11 non-member states, including Russia, to further reduce supply. During this period, OPEC's Secretary General expressed desire to add these additional 11 member countries as permanent members, stating that OPEC should have a permanent framework to sustain this platform. Yesterday, the Wall Street Journal reported that Russia is in advanced talks to formally join OPEC, dramatically expanding the cartel. These countries will meet on February 17 to ratify this collusive agreement. As my Republican colleagues have referenced, and as I've noted in this report, the ability of such an alliance to put a floor on oil prices would run counter to President Trump's goal of lowering gasoline prices for U.S. consumers ahead of presidential elections next year. There can be no doubt that the expansion of this cartel will come at the expense of American families, workers, and businesses. We'll see higher prices at the pumps, which, as Chairman Nadler noted in his opening statement, affects our country from top to bottom on an economy-wide basis. This would dramatically increase the cost of getting to work, taking your kids to school, and rebuilding our nation's crumbling infrastructure, and we should all be concerned about it. So I want to, again, just thank Congressman Shabbat, Chairman Nadler, and Ranking Member Collins for their commitment to taking on foreign oil cartels and for its quick consideration of the NOPEC Act. This legislation is really a testament to this committee's longstanding bipartisan tradition of investigating and addressing anti-competitive conduct that harms working families. And I look forward to continuing this work with my colleagues to ensure that our economy is working for everyone. And with that, I yield back with 0 time left.
I thank the gentleman. Without objection, the opening statements of all other members will be included in the record. Are there any amendments? Seeing no amendments, a reporting quorum being present, the question is on the motion to report the bill H.R. 948 favorably to the House. Those in favor say aye. Aye. Opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. This concludes our business for today. I want to thank all of our members for attending. The markup is adjourned.